I was reading in Lawyers Weekly the other day where they said that Dan Quick and Powell Miller are, quote, two titans in the Michigan legal community, unquote. I thought to myself, heck, I've known that for 10 years. Now, for our final act of this year's Business Law Symposium, we bring you a debate between former State Bar President Dan Quick and business law and class action dynamo Powell Miller. Their moderator, Gerald Rosen, is responsible for negotiating and settling the biggest bankruptcy this city has ever seen. In fact, it's the biggest bankruptcy ever in the history of the world, or the universe for that matter. Gentlemen, take it away.
Well, good evening, everyone. If we could come in and have a seat, please. I had lengthy introductions for Powell and Dan, but they were partially given earlier, so I'll just hit a couple of highlights that you might not know. Powell was in addition to being an outstanding lawyer, he was the National High School Debate Champion. And we'll see how he does tonight. And Dan was, in addition to being president of the Oakland County Bar Association, he was president of the State Bar of Michigan as well. They're both outstanding lawyers. They've both appeared before me when I was on the court, and I mediate and arbitrate with both of them regularly, and I consider them both at the very pinnacle of our shared profession. So without more, we'll get right to the debate topic. I see we're running short on time, so we'll try to get right to it. First, on the topic of litigation abuse and access to the courts, notwithstanding that we are not a loser pay system of justice, should courts more frequently or less frequently order sanctions for frivolous pleadings and discovery abuses? I think we touched on this in one of the earlier panels, but I'd like your views. Powell?
I believe sanctions are too prevalent and they're counterproductive. If anything, I'd like to see more judges sanction lawyers for improvidently bringing a motion for sanctions. Sanctions impair civility, they harm resolution, and they create counterproductive animosity and retaliation. I'll give you an example. A few years ago, I had a status conference before Judge Lawson. A lawyer I didn't know flew in from New York. In the hallway, she was so nice. She asked me for help on how to get a page extension. I helped her. I thought she was great. 10 minutes later, we're in the status conference, and she says, Judge Lawson, I intend to move for Rule 11 against Mr. Miller. So what I said was what Clint Eastwood once said comes to mind: go ahead, make my day. No motion was filed. Judge Lawson laughed. But it's a policy in our firm. Anyone files a motion for sanctions against one of us, we all work to defeat the motion for sanctions. We work 10 times harder to win the case. It is extremely rare that anyone tries, but anyone who has deeply regretted it. In my firm, no one can file a motion for sanctions without my permission. It's granted about once every 10 years, and when we file it, it has overwhelming merit and has won every time.
Dan?
Well, like most things Powell does, half of what he says was a straw man argument and the rest was just about himself. So there's no actual uptick or proof of uptick in sanctions being granted. And to the extent that there is an uptick in the request for sanctions, I might offer a few reasons as to why that might be. Perhaps it is because we hardly ever have live hearings nowadays in Wayne and Oakland County, somewhat more in Macomb, and we have lost our norm-setting quality that the judicial officer brings to the course of litigation, and so parties are acting more on paper and requesting sanctions, or actually engaging in bad behavior, or maybe it's a commentary on the erosion of our professionalism, particularly in a post-COVID world, where attorneys seem to have confused, I think I can make an argument, they said to themselves in the shower, with an argument that actually satisfies legal ethics and a professionalism in our practice. Moreover, the system is not healthy. The model of wide open front door to the courthouse, combined with let's all sort it out after the end of discovery, promotes fighting between counsel in a way that is unprofessional. So as one of the very few breaks left on expensive, bad behavior by lawyers, there is a time and a place. It's rare now. It should remain rare, but it serves a function.
Thank you both. I'm going to invoke the moderator's privilege here and tell one quick anecdote in my career. I was on the federal bench for 27 years. I think I granted sanctions, certainly in less than a handful of cases. Usually all it would take would be my looking at the lawyer and raising my eyebrow. I think it is a last resort, and lawyers should be very, very prudential before engaging in sanctions practice, because remember, sanctions practice can be like a boomerang. It can come right back at you later in the case. Next question. Is remote practice better or worse for the practice of business litigation, and in particular as to either in mediation, motion practice, and client interaction, or even all of the above? Dan?
I think for business litigation, it's worse. Now, anybody who disagrees with me is going to say, oh, well, he's got gray hair, so of course he's going to say that. That's the old way of practicing. But so much has been lost, not just in terms of advocacy, but in terms of our justice system. I understand the access to justice arguments that favor remote appearance at hearings, particularly for those who are unrepresented, so they don't have to take time off work or have to worry about daycare. There is a time and place for it. But the use of it to the breadth that it is now resident in the Michigan court rules, even though every judge is sort of free to disagree with it apparently, is too much. It's hurt the profession, it's hurt the younger generation of lawyers, and it's really hurt our justice system. The practice of law is not AI. You can't put in my motion to compel, Powell's response, and somehow come up with the right answer. Because the right answer is going to lie somewhere in between. And that's what the judicial officer does when they have a motion hearing. They quickly suss out who's BSing whom, and they, again, norm set, which then has an impact on the rest of the case. But just doing things remotely and not having hearings has hurt everybody.
I'm shocked. I agree with Dan Quick. I think remote practice is terrible. In law firms, in the courtrooms, in mediations, it weakens learning, camaraderie, teamwork, and harms efficiency. My firm permits it only in special circumstances, like where an attorney has a very long commute and he or she is enormously talented, like our associate Jimmy Pierce. Please stand up. He's the exception because he's a great young lawyer. But let me give you an example. I have a trial looming in Columbus on March 23rd. I'm working 24/7 right now for that trial. Today, I was able to walk down the hallway into Kevin's office, David's office, Craig's office, to ask for a document, a case for judgment on a line of cross-X. And it was a wonderful, well-oiled machine where I got that information like that. To try to get that by Zoom or email or call people up is not efficient. It's not the right way to do it.
And I'll just add my 2 cents. I'm probably well known for this. I don't like remote mediation or arbitrations. Doing things remotely is like 2-dimensional as opposed to 3-dimensional. And there's no substitute for being able to get people together, especially in mediations, over by the coffee machine and look at them and say, really? There's no substitute for that, and you can't really do that remotely. Next question. Does the idea or perhaps the custom of mediating every business court case early on in the litigation, does it increase or eliminate litigation? I think this is a topic that was addressed in the last panel as well, but I'd be interested in your views. Powell?
The required mediation of low-quality mediators is not helpful. But it's never too early or too late to have a high-quality mediator involved. We are blessed to have JAMS Detroit with the best mediators in the United States, and I have mediated with the so-called blue-chip mediators all across the country. And we are very lucky to have Judge Rosen, Judge Roberts, Judge Potts, Judge Langford Morris, and others who do an excellent job. And so there's...
I've made a note of that. Thank you,
What's
Paul.
that? Okay. So my view is, the key is the quality of the mediator. If it's just a rote exercise, it's a waste of money and can even be counterproductive.
Dan?
My answer is going to have less sucking up, but I partially
but feel
agree.
free. But feel free.
Yeah, but feel free, exactly. So, look, it was true 30 years ago, it's true today, 99% of all cases settle. But it is sophomoric to then conclude, well, then just let's force mediation on day one of the case, and they should all just settle earlier. That's not how it works. There's a lot of good reasons a case is simply not ripe for settlement early on, whether it's some key factual discovery that's necessary, a key legal issue that needs to be decided, or frankly, the clients just need to throw a few haymakers, appreciate how much it's going to cost, appreciate their downside, get some of it out of the system, and then they can come back to rationality. And good lawyers on both sides of the V understand when is the right time to dip in and do that. But sometimes people will even propose early mediation as a strategic thing because they've styled the case as being about X. And I'm going to say no, because I'm going to reframe the case and say it's not just about X, it's also about Y and Z, which of course is partially trying to put risk back on the other side. So if you just go along with it early on, you don't yet have the framing that you need to try to reach a positive resolution. So like many things, sometimes, sure. All the time mandatory, no.
Not surprisingly, I agree with both Powell and Dan. But there's a time and a season for mediation, and it depends on the case. Early mediation can be very effective in understanding the case better, in reducing costs, reducing the fatigue of the litigation. All of those things are true. But sometimes early mediation just doesn't have enough development for the reasons that both Powell and Dan said, and it can be frustrating for the parties, for the lawyers, and for the mediator if, for example, there's been no discovery on key witnesses and the mediator starts asking questions that really can't be answered because there hasn't been sufficient discovery. So time and a place, and good lawyers, seasoned lawyers, know how to make those determinations. Okay, next, Dan. Are the new ABA formal opinion 518, that restrict a mediator's advice to clients as to whether a party should accept or reject a settlement proposal, is that a good idea?
So I'm going to answer it both ways. First of all, it's a little bit of a lot of hullabaloo over nothing. So the main emphasis in Formal Opinion 518 expressed by that panel was a concern about more unsophisticated parties in a mediation context, where they may not really understand that someone of Judge Rosen's immense gravity is coming in there and not actually looking out for their best interest. He has no fiduciary duty to them. He doesn't have that sort of relationship. And so the intent was really focusing on the unrepresented, unsophisticated type party. Obviously, sophisticated business cases, everyone's going to understand the lay of the lay of the land. There is a statement in that opinion that says, a mediator may offer an opinion as to how a tribunal is likely to rule on an issue, but the lawyer mediator should not state or imply that a settlement is in the party's best interest because a tribunal is likely to decide adversely to the party.
what's the point of saying it?
Yeah, I mean, that's a lot of semantic hair splitting to me, and I'm not sure that it's going to change one iota of the way that mediators perform, because that's a key weapon in their repertoire. So there's some semantic issues there, but I think it's a whole lot of nothing.
Powell?
I think Dan is a little bit too quick on this one. The ABA Formal Opinion 518 is a clear and unequivocal disaster. The most effective way to settle a case is through a mediator's evaluation and recommendation. And I would defer to Judge Rosen on this because he is an extraordinarily experienced mediator.
Well, let me answer your question, Powell, by raising the question to the audience. How many of you would hire a mediator because you are not interested in that mediator's opinion as to the case? I think this advisory opinion is silly, and it's, as some organizations sometimes do, they get over their skis and they butt in where they have no business butting in, and they get beyond their expertise, and they really don't know what they're talking about. They're talking through their hat. I can't imagine that clients would hire me or my colleagues because they're not interested in our opinions. And this also begs the question of the times when we are asked for a mediator's proposal, which happens very often in difficult mediations. Would advisory opinion 518 say that that's not a good idea for the mediator to do, even though the parties have asked for it? It's a silly opinion. They ought to reconsider. Even though I understand your point, Dan, that it wasn't meant for all
Thanks for that bone. I
circumstances.
appreciate that.
Yeah. All right. Legal research, oppression lawsuits. Are shareholder oppression lawsuits too prevalent? Dan, I know you refer to them as in terrorem litigation, and you wrote an article, The Tyranny of the Minority. Are these cases becoming too prevalent, and do they need to be reined in somehow?
The short answer is yes. And it's a fault of a combination of both the substantive law and the procedures in our courts. So since revision of the MBCA many years ago to stress the oppression remedy is completely supplanted the traditional principles of the business judgment rule, including the derivative demand requirements that are built into the Model Business Corporation Act. And it is combined with the unwillingness of many state court trial judges now to rule on, let alone grant, initial motions to dismiss, which means you immediately are going to get into discovery. The net result of these two things is that you have a loosey-goosey tort with no gatekeeping going on up front in the judicial process, and any plaintiff with $250 and counsel far inferior to Mr. Miller can get into a case and turn a company upside down to try to extort a buyout or a settlement which they may have absolutely no validity in whatsoever. And what's worse is that within the business courts, there are some judges who, because they see so many of these ownership disputes, they've taken a Solomonic attitude about these types of cases and view it as their duty to look at it and go, oh yeah, these two parties clearly shouldn't be together anymore. And then they start leaning on the parties to buy out one party or another. That is a horrible dynamic for the judicial system, not to mention the intellectual niceties of what ought to exist within the business judgment rule in these types of cases.
Dan, you know, I've written down your answer, and the next time you come in on the plaintiff's side in an oppression case, I'm going to cite this back to you.
Well, there are some meritorious cases, Judge.
Powell.
Judge, you took the words right out of my mouth. I was going to say, Mark Rossman, I hope you're recording this because I believe I'm defending a shareholder oppression case brought by Mr. Quick. But my personal view is that shareholder oppression cases are not too prevalent. If anything, I think there should be more of them. The abuse by controlling shareholders over non-controlling shareholders is pervasive. Where there is control over money, the history of the world tells us that there is abuse. However, I do think there needs to be more thought about the ethics of plaintiffs' lawyers taking contingency fees in shareholder oppression cases, because it's pretty rare that the abusive controller harms the shareholder by a third. So if the abusive shareholder harms a party by 10 or 15%, but the lawyer takes a third, who's the oppressor? And I'm not saying they should be outlawed, but I think an ethical lawyer should look inside themselves before negotiating a contingency fee for a buyout.
From a mediator or an arbitrator's perspective, there's not enough litigation in this area. Sorry. Powell, after Murphy versus Inman, is it a good idea or a bad idea to bring a simultaneous fiduciary duty claim right alongside the member oppression claim, or is it duplicative or redundant, or perhaps one claim undermines the other? And you might remind us about the Murphy decision.
Well, the Murphy decision permits a breach of fiduciary duty claim so that the Michigan oppression statute is not an exclusive remedy. I will almost always bring both, because a claim under the oppression statute is tried to the court, whereas a breach of fiduciary duty claim that seeks money damages, you get a jury. So in a sense, you get two bites at the apple. I also believe that while the shareholder oppression case has some powerful remedies in it, sometimes more powerful than a breach of fiduciary duty claim, a fiduciary duty claim is broader. It can apply to any abuse arising out of a betrayal of trust and confidence, and gives a lot more flexibility to a plaintiff. So generally, I'd go with both.
Yeah, he's right.
Have that in writing?
Notwithstanding very inconsistent treatment of the oppression statute, at least in theory, it's constrained. It's affecting the rights of a shareholder as a shareholder. And there are some recent cases that actually are now suggesting you still apply the direct derivative analysis on top of the oppression claim. So because you can look through the cause of action, and if what's really being asserted is just a run-of-the-mill derivative claim, the court's not going to let you run it as an oppression claim. And that was in the Bordine case. And in the Frank's opinion, they suggested that Simon versus Simon, just from last year, that the business judgment rule still has something to say in the oppression context. But the beauty of the fiduciary duty standard is you get to bring out the old punctilio of honor line that we all remember from law school, because that fiduciary duty, you can wax eloquent as to how broad that is and what it means, and it can be very powerful. You can get to a trial on it.
Thanks. Let's talk about business courts and maybe even litigation in general. With one question, we've got 11 and a half minutes left. Who's the best fact finder for a complex business dispute? Is it the judge, the jury, or an arbitrator? Pick one. Dan?
What court am I in?
Or the mediator.
It's really hard to pick one, which goes to the point of emphasizing pre-litigation dispute resolution when possible, that the earlier panel talked about.
Yeah.
I am off three-person arbitration panels for the rest of my life. I'll never voluntarily sign up for one for reasons that may be obvious. Judge, with all due respect to Your Honor, who knows what kind of judge you're going to get? Arbitrator.
All judges are created equal.
People fight the split the baby
tongue-in-cheek
phenomenon with arbitrators. So I think if you can predict, if you're not happy with or confident with the hearing that you're going to get with your judge, I wouldn't hesitate to go to arbitration if it makes sense. But if you have a strong narrative through line, a real inequity that you can just pound and pound and pound, I wouldn't be scared at all to try it to a jury.
Powell?
If I have a strong case, particularly on the plaintiff's side, I want a jury every time. If I have a middling case, a plaintiff's case that's got some warts and barnacles, then I'm going to prefer an arbitrator or a judge, as there's more likely to be a compromise result. But ultimately, a lot of this will depend on who's the arbitrator and who's the judge.
Yeah. I'll leave that aside.
But let me, if I may, let me add to that,
please.
because you brought up business courts.
I did.
This is where and one of the panelists talk about this is where the aspiration of business court writ large, so I'm not talking about any particular judge, but it's fallen short, because the concept behind the business courts was that not only specialized knowledge, but much more active case management. From the day that case is filed until if it has to be tried, it's tried. For a lot of different reasons, that hasn't come to fruition, certainly across the totality of the business courts. And so I've seen more and more lawyers talk about taking cases into arbitration to avoid some of the randomness.
Yeah, and maybe even the publicity. Yeah. Powell, did you want to chime in again?
No, I basically agree on that.
Okay. This is a delicate question. It deals with what is confidential and what is not confidential and what should be available to the public. So the question is, should a business lawyer publish the results of business divorces in Lawyers Weekly or some other publication where the client hasn't given express permission? Powell, I think you're up.
Absolutely not. First, I think it violates the spirit of the agreement. If you agree it's confidential, you don't say anything about it unless the party that you entered into the agreement with agrees.
What if it's masked? What if it's done anonymously, in which they don't disclose underlying facts or parties?
I still think it violates the spirit, and I know of an instance where Roger Young, now deceased, was a great lawyer. He told me that he had a confidential settlement. It was put in Lawyers Weekly, and people were able to figure out which case it was, and he felt betrayed and was very angry. If we make peace, we need to honor our deals. The other problem is confidential settlements are not verifiable. So some lawyers will tout an $80 million settlement sounds great, but without knowing the context, without knowing the opponent, you don't know if that lawyer was offered $100 million to settle it and then ultimately settled it for $80 million and claimed victory. I think it's a bad look for our profession, and I think Lawyers Weekly should stop doing it.
Well, I doubt that we can expect that.
I agree with that.
Dan.
I mean, Powell's very passionate about this one, and I really could care less, because to me it's sort of like a victimless crime. I mean, first of all, are there tens of thousands of people reading the case summaries in Michigan Lawyers Weekly? And second of all, you know who wrote the summary. The lawyer wrote the summary. It's just fancy advertising. I don't know that it's even effective advertising, but unless it is a situation where it's identifiable, the case is identifiable because somebody didn't do a good job anonymizing it, that's absolutely out of bounds. The rest of it, I don't care.
I disagree. I think it is a victim situation because some lawyers have used and abused Lawyers Weekly to pump up their reputation and give the legal community an impression that they have expertise and amazing results in a certain area, and often they don't.
You see the billboards up and down I-75, right? I mean, this is not unique to the legal practice.
Billboards are different from Lawyers Weekly that purports to be like a report card, some type of objective analysis of what a lawyer achieved, and they publish the top verdicts and settlements every year. If some of those are phony, exaggerated, or misleading, then they harm our legal profession, and I believe some of them are.
Yeah, this is a delicate area. I actually have now in a case where there was a very, very tight confidentiality provision, a snippet in Lawyers Weekly that they clearly tried to anonymize, but I'm not sure that they were successful. And it can be damaging. All right, we're into war stories here. Powell? What's your best war story?
This may be my best war story. This is my third trial. I'm suing an insurance company, and I love suing insurance companies, for not covering a claim. My opponent had about 30 years of experience, so relatively speaking, I'm a kid. And we made a deal. We're going to tell each other the night before the witnesses that we are going to call. And I kept my word. I told him the night before who we would call the next day. We completed our proofs, but I did a smart thing by accident and intuition, and I think it's a great practice pointer. Never rest until you have to. I didn't formally rest. That night, I called my opponent, and I said, I told you, now you told me. Tell me, who are you going to call? He gave me his list. I walk in the courtroom, and there's Henrietta Hughes. Wasn't on his list. And I said, you didn't tell me you're going to call her. You're calling her first? And he goes like that to me. Now, nobody was in the courtroom. I came this close to having an Isaiah Stewart moment. But thank God I got my wits about me, and I got a little smart. I calmed down. I went over to Ms. Hughes. I said, Ms. Hughes, are you represented by counsel? No. Do you mind if I ask you a few questions? She said, sure. I figured out 4 points I could make with her. She was mostly bad for my side, but I could make 4 good points. So I shut my mouth. Judge takes the bench, brings in the jury, and says, Mr. Miller, so you rest? I said, no, Your Honor. Plaintiff is calling one more plaintiff's witness, Ms. Henrietta Hughes. My opponent jumps up and says, she's our witness. She's a defense witness. I said, Your Honor, she's on our plaintiff's witness list. I didn't rest. I have every right to call her. Judge said, go ahead, Mr. Miller, call your witness. So I surprised my opponent's effort to surprise me with the witness, surprised him right back, and he was rattled. And I thought it was a good moment for our side and a bad moment for his, especially since 2 days later, the jury gave us everything we asked for.
Great story, Powell, but because you called her as your witness, your opponent was allowed to use leading questions. So I wonder how that worked. Okay, Dan, war story.
All right, we're late at night, so I'll be brief on this one. This is about 15 years ago, jury trial in front of Martha Anderson, and I objected to a piece of evidence from the other side on hearsay grounds, and opposing counsel stands up and says, it's an ancient document. Now, unless you're in law school, I mean, how often does that come up, right? So everyone gets out their court rules and looks at it, and I believe it's 20 years. So is a thing.
9026, by the way.
And standing there in court, I'm having this existential realization that I am an ancient document, that I have been practicing for more than 20 years, and now I am considered ancient under the rules of evidence. So the judge looked at me, I looked at counsel, I was like, all right, whatever. He got it in, and that was it.
Great. I'm going to ask one more question. We've got almost 2 minutes left. And since all the other panelists went over, we can go over for a couple minutes. And you've already alluded to the fact that we're all older. So what norms, customs, practices, or methods from your earlier years in practice, Dan, are you disappointed no longer exist in the modern practice of law? And then I'll add one, if you don't already do it.
I think that, as was referenced in one of the earlier panels, it's very easy to throw elbows in this, and some people might accuse me of doing that on occasion. And it's hard not to get caught up on that on behalf of your clients and for the competitiveness of a case and how much it matters to your client, and hence how much it should matter to you. But there was, and it is not, I don't think, Pollyannish or overly nostalgic to say that there was more of a positive vibe of fighting it in court and going across the street and having a beer with opposing counsel in what was then a smaller community where you knew everybody and you realized that there were only so many bridges in the rest of your legal career, and you needed these relationships, and it was the right thing to do. And I don't, COVID made it worse to some extent, but I mean, I've thought long and hard as to whether or not that's just old guy talking, but I don't think it is. I think that really has eroded, and I think it's made everything not only more difficult, it's made it harder to represent our clients, but it just has made it less enjoyable.
So, from another old guy, I'll read you what I wrote down for my answer. Going out for a drink with opposing counsel after the trial. Powell.
Take that, Powell.
I wholeheartedly agree with that. And in fact, many people I've hired in my firm were my opponents. I apologize that I have not sent you an offer yet, Dan. But what I also think has been lost is the art of oral argument. In the older days, more judges, more consistently, had oral argument. I miss oral argument. I think it's an important part of advocacy.
Did you miss it when you were practicing in front of me, Powell?
Well, you would always, I remember, I'll tell you a Judge Rosen story. He called us into chambers, and he said in the Tecumseh case, sorry, Powell, I'm denying your motion for a class certification, but I'll let you make a record. So on my feet, I shifted to an injunctive relief class certification, and I at least got Judge Rosen to do a 360 in his chair, say that's interesting, I'll think about it. But then he issued an opinion 10 days later, and I lost. But at least I was able to give it the old college try. One other thing, and I really don't like this, and is there are too many judges who are being way too restrictive on leave to amend and are prematurely denying motions for leave to amend early in a case before meaningful discovery. Rule 15 says that leave should be liberally granted. And I believe that I should have one chance to amend after, at least one chance, after I understand why the judge thinks my case should be dismissed, so I have a chance to revise my pleadings to satisfy the court. Too many cases are getting kicked too early without leave.
Well, thanks to both of you. Great night. I'm going to close with an editorial comment in support of Michigan lawyers. I've had the privilege in my career of sitting as a judge by designation in courts all over the country, both appellate courts and district courts. I've had the privilege of as a mediator and as an arbitrator, to mediate and arbitrate all over the country. And I think both Powell and Dan here are exhibit A as to why Michigan lawyers don't have to take a back seat to lawyers from the other big firms. I can tell you I've sat as a judge, I've sat as an appellate judge, I've sat as a mediator, I've sat as an arbitrator on countless lawyers from all the big firms, lawyers with big reputations. And lawyers like Powell and Dan don't have to take a back seat. So my advice to you folks, especially you younger folks, when you go out and you have big names on the other side, big firms, don't feel like you have to take a back seat. Don't feel like you have to back down. Michigan lawyers are every bit as good, every bit as sophisticated, and every bit as able to hold their own as lawyers from all over the country.
Hear, hear.
I wish there were some general counsel in the office, in the room here.
Okay, thank you.
This concludes the 2026 8th Annual Business Law Symposium. Thank you for attending, and we hope to see you next year on February 11th, 2027. We'd like to give a special thanks to all of our presenters, support staff, vendors, and the incredible hospitality staff of the Gem Theater. And thank you to all who attended here at the Gem, and for those of you watching online. You are all amazing. Now go do amazing things. Good night and Godspeed.